Okay. You are Miss Bell?
Benton.
Ben-
I'm sorry, Your Honor. Miss Bell stepped to the side for a moment. Can we circle back around to her?
yes, sir. Miss Benton, ma'am, you're charged with one count of possession of marijuana less than an ounce. The bond is going to be set at $1,500. Do you believe you can post that bond?
Yes, sir.
This is a misdemeanor charge, so your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of an attorney?
Can you repeat that for me, please?
Your preliminary hearing date is going to be set for, hold on, I'm sorry. Let me stop this glare. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure, yes, yes, sir.
Okay, I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Go sit in the back. Bell, step up.
Miss Bell, ma'am, you're charged with one count of robbery by sudden snatching. This is a felony offense. Bond is going to be set at $5,000. False imprisonment is also a felony offense. Bond is going to be set at $3,000. Simple battery, bond is going to be set at $3,000. That's a misdemeanor. And use or possession of drug-related objects, bond is going to be set at $1,500. That's a misdemeanor also. So that's a total bond of, let's see, $9,500. Do you believe you can post that bond?
No.
Okay. There's going to be a stay away provision on this bond to stay away from a Paula Nash. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out or your ability to post bond, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, and a reduced bond.
Okay, give me 1 second. I'm going to find that you do qualify for the appointment of a lawyer. And is there any one factor that you're pointing to that you believe I should consider in reducing your bond?
My kids.
I'm sorry.
You said, do I do what? I couldn't hear you.
Is there any one factor that you are looking at for me to consider as to whether I should reduce your bond?
Yes, my children.
Is there anything else?
No.
Okay, I'm going to deny that request. Mine's going to remain the same.
Step up close to the
That don't
back.
make no sense.
Hey, step to the back. Next
I
up.
get on my fucking nerves.
Yeah.
Don't touch me.
I'm not touching the surface, but don't touch what you do. Step out and have a seat out.
Are you Miss Charles?
Yes.
Ma'am, you've been charged with one count of disorderly conduct. Bond has been set at $1,500 by schedule, which means it was automatically set. Do you believe you can post that bond?
No.
Okay. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post bond, and you'll receive a new court date in the mail. Now, ma'am, you are aware that if you post this bond through a bonding company, it's going to be approximately between $150 and $200.
The problem is I'm not from here.
Okay. So, let me see. You're from, is this Missouri?
Minneapolis.
Okay, Minneapolis. Sometimes the bonding companies, you can contact family in the county where you live and make arrangements with a bonding company there so that they will come on the bond and associate a bonding company here. My understanding is that the main issue with bonding companies and posting bonds for people who live out of state is that if you were to choose to not come to court, the bonding company is in a position of either paying that money to the county or to come and get you. They would have to expend resources to come to Minnesota or Minneapolis, I'm sorry, to locate you. But if there's a local bonding company that has associated with them, that local bonding company would then take on the burden of finding you if you were to choose to not come to court. So contact your family, your friends in the county where you live, or even a bonding company if you don't want to go through your family and friends that is there. Advise them of your situation and see what they can do for you.
Is there any way you can reduce it so I can just pay it myself without the whole bonding company thing?
So these bonds are set by schedule, which means that a group of judges sat down and determined certain offenses are ones where we're just going to place a certain bond so that person doesn't even have to go before a judge. They can just post a bond and bond out. Now, in situations where people live out of state, that presents a unique problem because, as you, I think, have found out, bonding companies are reluctant to sign on bonds for people who live out of state. So I'm not going to reduce it because this has been something that sat down and other judges have made the determination that this should be the bond that is set by schedule. But I'm sorry.
How much is it again?
$1,500. Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh, yeah.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No.
Okay. You're free to go back.
Never see that. Step up, please. Thank you, ma'am.
Francis Johnson.
Ms. Johnson, before I get to Ms. Johnson, I'm just going to state, you can stay there, ma'am. I'm just going to state for the record that I was informed that Imani Copeland is currently in the COVID protocol. She has a misdemeanor charge of criminal trespass. I'm going to set a bond of $3,000 for that, so that she does not have to sit in jail and wait to come back out of COVID protocol. If she can post a bond, she will be free to leave. Okay, Ms. Johnson, ma'am, you're charged with 1 count of simple battery. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yeah.
So there's going to be a stay away provision on the bond, and I could barely make out the handwriting of the officer, but it looked as though the last name is Solomon, Saloman,
Yes,
and
that's right.
here. Okay, so there's going to be a stay away provision to stay away from that person. Do you understand, ma'am?
Yes, I do have a question. He lives with me?
Give me 1 second. When I'm done informing you of the information, I'll let you tell me whatever you need to tell me, okay? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. Do you plan on hiring your own attorney?
No.
Would you like for me to see if you qualify for the appointment of an attorney?
Yes.
Okay. I'm going to find that you qualify. I'm going to appoint an attorney to represent you. Now, what was your question, ma'am?
So that officer lives with me.
Okay.
So does that mean he has to leave or?
Well, if the alleged victim is the person that lives within that residence. As a judge, I cannot put an alleged victim out of their home. So to the extent that that person lives with you, you would have to leave
But that's,
until, hold on, ma'am, hold on. You would have to leave until that condition is either lifted or modified.
even though I'm the homeowner,
Yes. So let me reverse the situation. Let's say that you and I are boyfriend, girlfriend, and you live with me, and I just beat you every day just because I feel like I can. And then one day you gather the courage to call the police and I get arrested because I've been beating you. Do you think then I should be able to turn around and evict you out of the home just because you reported the fact that I was beating you?
in your circumstances, no.
So, ma'am, you and this other person are adults, okay? I've been married for 19 years. The police have never come to my home. I don't know what happened. All I know is what is written here. And I have to go upon what is written here. Okay? Now, if this person is not afraid of you, that person can contact the solicitor's office and say, hey, I want that condition to be changed. And they'll look into it. If they agree, they'll change it. But because there's such a quick turnaround between arrest and being bonded out, whatever happened yesterday, we don't want that situation to flare up tonight. Okay? Any other questions, ma'am?
No.
Okay, ma'am, you're free to go back.
Next.
Is it Miss Kochinski?
Yes, sir.
Ma'am, you're charged one count of simple battery. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Damon Snyder. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I don't.
Okay, ma'am, you're free to go back. Miss Lewis?
Yes.
Ma'am, you're charged with one count of following too close. The bond is going to be set at $500. One count of hit and run, leaving the scene of an accident. Bond is going to be set at $1,500. And one count of driving a vehicle without a valid license. Bond is going to be set at $1,000. Do you believe you can post this bond of $3,000?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back. Miss Pittman Smith, Mr. Fortas, I saw you log in.
Hey, Judge, I'm sorry. They told me 11 o'clock today.
Yes, you're fine.
Okay.
Everybody was ready to go early. I knew that your clients were on this calendar, so I was just going to hold.
Thank you, Judge. I appreciate that.
Yes. So, Ms. Pittman Smith, the same thing applies as of Monday when we appeared. Mr. Fortas, there's new charges, false report of a crime. On yesterday, Mr. Ruiz appeared before me on 2 burglary counts, and there's another charge that I can't recall at the moment. and it was indicated in the warrantless arrest affidavit that Ms. Pittman Smith and Mr. Adonis Smith allegedly told the officer that Mr. Ruiz did not live there and had not been there, I believe, for over a month, or lived there for over a month. And I recall from the hearing on Monday and from the arrest on I believe the 22nd of your clients that Mr. Ruiz in fact did live at that location. And so that is what is forming the basis of this charge. The way that it's written in the warrantless arrest affidavit, it says that both Ms. Pittman Smith and Mr. Adonis Smith alleged that Mr. Ruiz was committing the offense of burglary. And the way it is written, it could be a theft, it could be whatever. I don't know. But I've set bond for both your clients at $5,000 on this offense. I'm not seeking to revoke their bond or take any other kind of punitive action against them. But that is what forms the basis of this charge.
And that's fine, Judge. I don't know how much you want to hear on it, but, you know, I echo the sentiments that we discussed, you know, a couple of days ago at the bond hearing regarding the Pittmans. And just to add a little bit of background on it, from my understanding, and this will come out later at a different hearing, at a different time, in a different manner, that Mr. Ruiz assaulted, you know, Ms. Pittman. I'm not here to say whether it happened or it didn't happen, but there's a pending TPO from my understanding. I'm not involved in that, where they're trying to gain service. But however, Mr. Ruiz had sent an email or a text message to Mr. Pittman indicating that he's left the premises and is elsewhere. That's what gave rise to the representations that were made to the court. Where his whereabouts were or are, my clients had no idea. My clients went to Home Depot to make an exchange of an item and received a call from a neighbor that Mr. Ruiz was breaking into the house. And then that's when they came back and found that some of their items were missing from the home. So that's what gave rise to the police being called and the representations being made. And that's what my clients have informed me. And it's just, I'm sure Your Honor can see it. It's just a mess that's just going to have to get sorted out at another time. But I appreciate the bond, and I appreciate you not revoking the bond. But I just wanted to give you a little bit of background because I didn't want you to think that my clients were telling me something and I was representing something to the court that was not accurate. Now, this is from my understanding, and we're delving deeper into that, and it'll shake out the way it will. But I just wanted to let you know that my clients did not have any ill will on that, and this is kind of what's been going on over a period of time, and it'll flesh out one way or the other. But I do appreciate the court's time.
Okay, and let me ask you this question. And if you don't know, you don't know. You said that the TPO had been applied for, but it was waiting for service.
That's my understanding, but I don't know. That's what I was told. Now, obviously, I haven't had an opportunity to speak with my clients, so this came through secondhand information through a family member through them. And we were talking about if they weren't able to ascertain where he is, how they're going to get him served. And I was kind of explaining the process. But, you know, I came in this morning, found out that they were incarcerated, and jumped on the call. So I haven't really been able to really get into it. And so what I have is just a general overview of what I know. So I don't want to misrepresent anything to the court. It's just what I was told, and I haven't had a chance really to delve into the matter any deeper.
Okay. And the reason I asked is because normally if someone is in custody, we don't always know at the time, but that of course is the easiest time to serve someone.
Sure.
Is when they're in custody. I will be doing ex parte TPOs next week. So I'm gonna check and see who's doing it this week, because this is something, in my opinion, it's just too many loose tentacles out there, and I believe all of this needs to get wrapped up so that the core issues can be resolved and dealt with. So, Mr. Smith, you also have a $5,000 bond, and you're in the same position as Ms. Pittman Smith. I'm not taking any adverse action against the bonds that were issued before, and I will see if Mr. Ruiz is going to have to get served. So I'm gonna check and see what the status of that ex parte petition, just so that all of these matters can get heard and resolved. Mr. Fortis, I was going to place this issue on the same calendar as the preliminary hearing before, but your clients bonded out, and so that is not going to be an issue. Sometimes the district attorney's office parcels cases out, even if it's involving the same parties, and somewhat similar issues. If it's a misdemeanor, they'll send it down to the solicitor's office. So currently the date that we have for preliminary hearings is February 8th at 8:30 in the morning for misdemeanors. But of course, your clients bond out, that case will get resolved. And if you have that documentation or those communications as it relates to Mr. Ruiz, that should, well, it could, I gotta speak like a judge, it could form a complete defense to these charges.
And Judge, I'm going to meet with them this weekend once they secure a bond here. The only thing I would like to inquire about the court, and you may not know the answer, is when Mr. Ruiz was before the court, was there a stay away from the Smiths, or at least the incident location, if the court will recall?
No, I did not.
Okay.
I did not place a stay away. These situations become complicated, as I'm certain you understand. I think the young lady earlier, when she was the alleged offender, but it was her house and the alleged victim was there, and there's stay away. So my position is not to get deeply involved at first appearance. Preliminary hearing is something totally different, where I can ask questions. But I did not place a stay away provision there. And if those communications exist as it relates to Mr. Ruiz, to your clients, I believe that they should print those out and keep those handy.
We're aware, Judge, and I just want to thank the court for your understanding, and they should be able to make bond. I'm going to call their family member right away, and I appreciate not revoking their bond, and I appreciate that. Thank you very much.
Okay. Ms. Pittman Smith and Mr. Smith, you're both free to go back, and Mr. Fortis, you're free to go, sir.
Thank you, Judge. Have a great weekend.
You too.
Happy New Year.
Happy New Year to you too. Ms. Pope,
Yes, sir.
ma'am, you're charged with one count of simple battery. The bond is going to be set at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on this bond to stay away from a Darrenith Booker. Do you understand that?
Yes, sir. Even though she stayed in my house? Same.
Yeah, it's the same situation, you know. The court's hands are tied pretty much at this point as it relates to that. There's going to be a preliminary hearing date set for February 8th at 8:30 in the morning, courtroom 201. That date will will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, ma'am. Miss Swinging.
Yes, sir.
Okay, ma'am, you're charged with one count of simple assault. Bond is going to be set at $2,000. Do you believe you can post that bond?
No, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond. There's going to be a stay away provision on this bond, to stay away from a Paula Nash. Do you understand that?
Sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Miss Wooten. Ma'am, you're charged with one count of simple battery. I've set the bond at $1,500. Do you believe you can post that bond?
No.
There's going to be a stay away provision on this bond to stay away from a Journey Benton. Do you understand that?
That's my granddaughter.
I understand. Do you understand that?
Yeah, you need to tell her. Yes,
Okay.
I'm saying. So can I,
Hold on, ma'am.
okay, I'm sorry, go ahead.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, what was it that you wanted to tell me?
Oh, I was saying, well, the bond will reduce from 1,000, it have to be 1,000, so I can't bond that, right?
You can go through a bonding company and pay approximately $150 to $200.
Okay.
Okay.
Mm-hmm.
Is there anything else, ma'am?
Sounds
Okay,
good.
ma'am.
Thank you.
You're welcome. Free to go back.
Mhm.
Definitely the last female, Your Honor.
Okay, thank you for your assistance. Let's switch over to the male side.
This is Mr. Admiral, Your Honor.
Okay, Mr. Admiral, sir, you're charged with one count of interference with government property. Bond is going to be set at $5,000. One count of obstructing an officer. Bond is going to be set at $2,000. And one count of financial transaction card fraud. Bond is going to be set at $5,000. So the financial transaction card fraud is a felony. The interference with government property is a felony. And obstructing an officer is a misdemeanor. That's a total bond of $12,000. You believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. Do you have any questions of me?
Yes, just one question. When I got booked in, even down to getting processed in, they told me I only have one felony, which was the fraud. The other two was misdemeanors. So on your end, is that correct?
The interference with government property is listed as a felony. And the financial transaction card fraud is listed as a felony. The code statute for the interference with government property is 16724. So if it's a misdemeanor, then you have two misdemeanors and a felony.
Yes, sir.
Okay. Anything else, sir?
No, sir.
Okay, you're free to go back.
Thank you.
The black.
Want to be like that, they allow you to be like that. Go ahead and report those, so you get it straight up.
Get messed up with. Appreciate it.
Mr. Blackman, sir, you charged 1 count of loitering or prowling, 1 count of obstructing an officer. I have dismissed both of these charges. When the paperwork is received by the sheriff's department, you will be released. Mr. Goss,
Yo, keep noise down, keep noise down.
Mr. Cost, sir, you're charged with 1 count of criminal trespass. It's a misdemeanor. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Kelly Briggs. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
But it's a misdemeanor, right? Yes, sir.
Yes, sir. Yes, sir.
All right. Thank you.
Okay, you're free to go back.
Davis.
Mr. Davis, sir, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000. 1 count of false imprisonment. Bond is going to be set at $5,000. And 1 count of cruelty to children in the 3rd degree. Bond is going to be set at $3,000. The false imprisonment is a felony. The other 2 counts are misdemeanors. You're going to have a total bond set at $13,000. Do you believe you can post that bond? There's going to be a stay away provision on this bond to stay away from a Virginia Burgos. Do you understand that? Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
What's your question, sir?
I was trying, I don't know how to put this, but this has happened like 4 or 5 times, and she's at this court, she's using this court as a tool. She's dropped the cases. Even on this one, I wasn't even around. When I'm ready to start the process of, putting a restraining order on her, eviction notices and a divorce type thing. You know what I'm saying? Because I'm tired of this. How can we stop using the courtroom as a tool to arrest me?
Are you still with Ms. Burgess, Mr. Davis?
Yes, sir. I'm done, sir. Really, this time.
That was not my question. I said, are you still with her?
Yes, sir. She's probably
So,
gonna
Mr. Davis, if she's done this 4 or 5 times, why do you keep going back?
my son. It's an excuse, I know. I know.
Mr. Davis, you are an adult. I can't try your case right now. I can't make determinations. So all I can do for you, sir, is to tell you that unless this is something that you like doing, maybe you need to do something differently. Okay?
Yes, sir.
Anything else?
No, sir, thank you.
You're welcome. Okay, before we get to the next person, for the record, Mr. Enrique Etane is charged with simple battery. Bond's going to be set at $3,000. He and Miss Copeland are both in the same boat, boyfriend, girlfriend. And as I did with Miss Copeland, I'm going to do with Mr. Etane. I'm going to set a bond of $3,000. I'm going to remove the stay away provision. I understand he's in COVID protocol. And so this will allow him to bond out if he is so desirous or willing to do so.
Yes, Your Honor.
Okay. Let's see, Mr. Flores.
So what?
Hector Flores.
Yes, sir.
Sir, you're charged with one count of following too close. Bond is going to be set at $500. One count of driving a vehicle without a license. Bond is going to be set at $1,000. One count of having a tag that is concealing the identity of the vehicle. Bond is going to be set at $500. And knowingly driving a vehicle with a suspended or canceled registration. Bond is going to be set at $500. So that's a total bond of $3,000. Do you believe you can post that bond, sir?
I don't know. Yesterday I talked with my wife. She's telling me kids outside. I don't know if she's paid my family or I don't know.
Okay. So she may have posted the bond because this whole situation starts so early. You may have been caught in that gray area where instead of going to bonding, you're sent to court. So the one benefit is that I can ask you the question of, do you want me to see if you qualify for the appointment of a lawyer?
Oh yes, I have the friends, Johnny Castellera.
Okay, so you have a lawyer?
Yeah, it's a friend, long time.
Okay. Do you have any questions of me, sir?
Only I can't talk with my wife right now. I don't know. She's paid. My family paid.
The short answer is that once you leave this proceeding, you will be allowed to use the telephone pursuant to the sheriff's department's policies. So I can't tell you exactly when, but I know you will be allowed to use the phone.
Yes.
Okay.
Yes.
Okay, so you're free to go back.
Thank you so much.
You're welcome.
Fulton. Fulton.
Mr. Fulton, sir, you're charged with one count of aggravated assault. That's a felony. Bond is going to be set at $10,000. One count of battery. Bond is going to be set at $5,000. One count of misdemeanor possession of marijuana. Bond is going to be set at $1,500. And one count of driving a vehicle on a suspended license. Bond is also going to be set at $1,500. So that's a total bond of $18,000. Do you believe you can post that bond?
Yes, but why do I have a driver on suspended license when this occurred in the house?
Okay. Give me 1 second. So there's an allegation that both you and Miss Hoyle told law enforcement that you took Miss Hoyle's red Ford Focus from the apartment and returned intoxicated after multiple hours. They checked your information and said that you had a suspended license for failure to appear with a violation date of May 28th of 2008 and a suspension date of June 15, 2009. So they're basing the driving while suspended, driving on suspended license charge, apparently from statements that were allegedly made by you and Miss Hoyle.
Okay, it seemed like that should be something that could possibly get thrown out, but okay, all right.
Okay, so there's going to be a stay away provision on the bond, stay away from a Shatoya Hoyle. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
No, no, Terry, Mark, no. Come on down. Take your time, sir, take your time.
Mr. Knowles, sir, you're charged with one count of aggravated assault. Bond's going to be set at $20,000 and one count of battery. Bond is going to be set at $5,000. That's a total bond of $25,000. There's going to be a stay away provision on this bond to stay away from a Thomas Knowles. Do you understand that?
Yeah.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, I do. I need,
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
no,
Okay.
yeah, thank you.
Okay. You're free to go back, sir.
Just take a seat, Mr. Mallet. Angelo. Yo, hey, come on.
Going on, Bobby?
Good morning. Tell me your name, sir.
Yes, a little map.
Mr. Mallet, sir, you're charged with one count of theft by taking as a felony. Bond is going to be set at $5,000 and one count of giving false name, address, date of birth. Bond is going to be set at $1,000 for a total bond of $6,000. Do you believe you can post that bond?
Sir, I didn't take this.
That was not my question.
No, I'm saying, how did I get that warrant? I don't know nothing about it.
Sir, you are presumed innocent until you're found guilty, so you do not have to tell me that you are innocent. You stand here as an innocent man. Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. All right, hold on one second. Okay, so you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back. Did we lose Mr. Okay, Mr. Montgomery?
Appreciate it.
Oh, you good?
Okay. Mr. Montgomery, sir, you're charged with one count of criminal trespass, damage to property. This is being written as a misdemeanor. Bond's going to be set at $3,000. Do you believe you can post that bond?
Oh, yes, sir.
There's going to be a stay away provision to stay away from a Shahavanika Johnson. Do you understand that?
Yes,
Hold on. I'll let you get to your questions and the end. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, I cut you off, Mr. Montgomery. What were you going to tell me?
I was trying to ask about the stairway, cause this nigga ain't too happy about me being in here, and that's my place of residence. Like I pay my rent, I pay the bill, the whole all bills and all of there. Like, and plus I have my only child staying right there too, man.
Okay. Well, Miss Johnson, I believe, is the person that reported this to the police. If Miss Johnson does not like the stairway provision, first, she cannot choose not to call the police in the future. Or B, she can contact the solicitor's office and let them know of her desires, and they will look into this case, and then they'll make their own independent determination as to whether they believe this provision should stay in place or whether it should be lifted or modified.
So is there any way she can be notified of calling the solicitor?
I'm pretty certain that there's a victim witness person that may have already reached out to her. So I'll just tell you my observations from the bench. Almost half of our cases are adults acting like children. Calling the police, and police have to come out, have to deal with refereeing disputes between adults. Sometimes the person calling the police is just angry and upset.
Right.
Sometimes the person calling the police is in absolute fear. Nobody knows you or Miss Johnson. So we take the approach that the person was in complete fear until we are moved or informed otherwise. Okay, so this is being taken seriously. It's not being looked at as, oh, this is just two people and she mad and that's why she called the police. No, this is being looked at as public officials. We have a duty to protect the public. So this will get diverted over to the solicitor's office. They will look into it and they'll make their determination as to what's going to happen. Okay?
Sure. And my bond $3,000?
Yes, sir.
Yes, sir.
Okay, you're free to go back.
Richardson.
Mr. Richardson, sir, you're charged with one count of driving under the influence of alcohol to the extent that you're a less safe driver. Bond's going to be set at $5,000. One count of driving a vehicle without a valid license. Bond's going to be set at $1,000. One count of following too close. Bond is going to be set at $500. And one count of hit and run accident, leaving the scene of an accident. Bond's going to be set at $1,500. So that's a total bond of $8,000. Do you believe you can post that bond?
Excuse me? Excuse me?
Gentlemen.
Yes.
I don't understand the question.
Do you believe the bond is going to be set at $8,000? Do you believe you can post that bond?
No.
Okay. You understand you have the option of going through a bonding company where you're going to pay approximately 10 to 15% of the bond.
Yes. I would like to say something.
Okay, I'll let you get to that in 1 second. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was it that you wanted to tell me?
Actually, the driver license, I have an international driver license. It was on another car. I didn't have it on me.
Okay.
The police took a picture of my picture. I have it in my phone.
Okay. Okay. So I've appointed a lawyer to represent you. You should provide that information to the lawyer. And these charges are charges that require the state. Actually, it's going to be, I believe, primarily proven as it relates to documents or documentation. So any kind of documentation that you have to support what you just told me will be sufficient. Is there anything else, sir?
Actually, an issue the police have brought me yesterday night. When they arrested me, they took my wallet, my phone, and everything. And I had about $385 cash in the wallet, and I showed, but I never got the wallet back. So when I reached here, I didn't know how the procedure is because the first time I've been doing this thing. So when we went to check, the money in my wallet was gone.
What happens most often, and I don't know if this happened in your situation, but if there's any kind of cash, the cash is noted, taken, deposited, and when upon bonding out, you'll receive a check for the amount that was taken out.
Well, they never did that with me. So when I reached here, and then someone told me, hey, you have to check, you have to receive and check all your belongings. Then I went back. And then by the time we check everything, that money was gone. And I told the police that arrest me, I have my money there. It's 3 bills of $300, 3 bills of 60, 2 of 10, 1 of 5, and about 60 something cents was in my wallet.
Okay. And all I'm saying is that I understand that to be the practice, just so that it's not a situation where your wallet is placed into evidence and it has $300 in it. And then when you're getting your property back, the money is gone. So you should speak to your lawyer and check to make certain that there is a receipt for the money, the cash that was taken out of your wallet.
Well, it looks like that when they reached here with me, the money was gone already. So actually, it's the police that brought me here. So,
sir, all I can tell you is to take those steps that I've currently advised you of. I cannot go down to property and start looking for your wallet. I cannot call the officers and ask, hey, did you take $300 and some odd? Okay. I'm trying to tell you the whole lay of the land. As far as I'm concerned right now, the range of possibilities is that one of those officers stole your money, or they took your money, inventoried it, and there's a receipt. Okay.
I told them I was over here, so they said they were going to check on it.
Okay, let me ask you this question, and then we're going to move on. What is it that you would like for me to do as it relates to this money?
Say again, what is this?
What is it that you would like for me to do as it relates to the money that you said was taken out of your wallet?
Well, I spoke to
No. The question is, what do you want me to do about it?
Well, I was trying to get my money back because my money gone. Somebody took it.
I understand that. What do you want me to do about it right now? What is it that you think I have the power to do?
So, no, I'm just mentioning it to you, so I know someone, so.
And I gave you the range of possibilities and I gave you some suggestions as what to do. And we're still talking about the money. What is it that you think I can do beyond what I've already done?
No, sir, I just mentioned it, and I'm trying to get my money back, but I don't know how it works. I don't know how it works.
Okay, sir.
Yeah.
You're free to go back.
Okay,
I've
so-
made a notation of it.
And, the bond will, I have to talk to the company? Bond?
Yes, sir.
My court will be on 7th of February, right?
When you bond out, it was the 8th of February. When you bond out, your case will get, that court date will get changed to a new court date. Okay? Okay, sir, you're free to go back.
Mr. Riley.
Mr. Riley, sir, you're charged with 1 count of criminal trespass. I've dismissed that charge. You're also charged with 1 count of illegal parking in handicap zone. Bond is going to be set at $500 for that offense. So your total bond is going to be set at $500. You're going to have a preliminary hearing date set for February 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment? Oh, it says you refuse. You're going to hire your own lawyer?
No, sir.
You're going to represent yourself?
Yes, sir.
Okay. Do you have any questions of me?
No, sir.
All right, you're free to go back.
Bradshaw. Bradshaw. Mr. Knowles, go there.
Let's see. Tell me your name, sir.
Roman Gresham.
Okay. Sir, you're charged with 1 count of harassing phone calls. Bond's been set at $1,000. You believe you can post that bond?
No, sir.
There's going to be a stay away provision on the bond, stay away from a Waveney Irving. Do you understand that?
No, sir, I don't.
Okay. What do you not understand about that?
We are legally married. That's my place of residence. We have 3 kids together. I just started a new job working at the airport and I missed work yesterday. I was supposed to clock in and work tonight at 10 p.m.
So it sounds like you understand the stay away provision. You just disagree with it.
I don't understand how I'm supposed to stay away from her if that's my place of residence.
Because she's the victim and you're the alleged offender.
Well, I understand that, Your Honor, but it's gonna get resolved anyway because it's only a verbal, altercation. We never got physical. We don't do this on a regular basis. But I'm not even from the state. I've been here for about a month. I just started a good job at the airport. We about to move from an apartment into a house. So that's why I can't make the bond, but I understand.
Okay. So if you were to violate this condition, you could get charged with aggravated stalking and be in jail until your trial, which would certainly lead to your losing your job. Do you understand that?
Yes, but why does the no contact order have to be put? I mean, she's not pressing any charges. We're not arguing no more about it. Like, that's where my daughter stayed. That's where I live at. I don't have nowhere to go. That's my home. I'm on the lease and everything. How am I supposed to stay away from my wife?
Okay, so this is the wife is the mother of your child?
Yes, sir.
The allegation is that you texted her 8 times, threatening to shoot both yo MFers.
Her and her friend, her and her home, yes, her and her girlfriend were like,
So,
oh,
Mr.
all the time, sir. I don't
Sir, if you didn't know me and you are in the position of deciding whether I get to go back around my wife or not, and the only information you have is that I told my wife I'm going to shoot, I texted my wife 8 times, I'm going to shoot both you MFers. Do you think it is reasonable for you to say, oh yeah, I don't know you, but go back? Ain't that gonna happen?
I don't get the question because I know my wife. Like,
Yeah, I don't know you. Sir. This is real simple. Don't send text messages threatening to shoot anybody, and you won't be in jail. You won't have a stay away provision placed on you, and you'll be going to work tomorrow. But if you decide to send those text messages and the police get involved, we have a responsibility as a judicial system for public safety. We don't know you. We can't do a blood test to determine whether you're going to go and shoot and kill somebody tonight or not. We don't. So we got to take bright line precautionary measures. The way that you keep yourself out of this is don't send threatening text messages. Don't threaten people, whether you believe it, whether you are true about it, all of that stuff. So don't come to me asking me to place you in a position, as they would say, the fox guard in the hen house. I don't know you. The solicitor's office, they will do an investigation. They will determine whether it is safe for the two of you to be together. But I'll tell you this, whatever relationship you have, the fact that you're sitting here in jail, maybe you need to reconsider the relationship. That's all I'm saying.
this wasn't, I wasn't supposed to be in jail. Like,
Okay. Your preliminary hearing day is going to be set for February 8th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
sure, why not? I ain't going nowhere.
All right. You do
Bullshit
qualify.
Yo, you're not done yet.
Fucking stupid ass shit, man. What you up to?
Sir, that comment that you just made right there is sufficient to have you held in contempt of court, which could be up to 30 days in custody.
I'm already here. I'm already locked up in jail as it is, man.
Because of your actions, which by what you've displayed so far, I think I'm going to see you a lot. So we should get to know each other.
I don't get clout. I'm a family man, okay? I'm here to talk to my wife, so you ain't gonna see me again, Your Honor.
We should get to know each other because I don't believe you can control yourself.
Your Honor, you know him?
Yeah,
I'm done.
Step up.
Thank you.
Victor Smith.
Mr. Smith, sir, you're charged with 1 count of aggravated assault with a deadly weapon, 4 counts of violation of Georgia Controlled Substance Act. Those are all felonies. I've denied bond at this point on those felonies. You have a misdemeanor charge of possession of marijuana less than an ounce. There's a $1,500 bond set. There's going to be a stay away provision on the bond to stay away from a Sawana Randolph. Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for February 11th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I don't know the reason, but I was wondering what was the reason why you can't set a bond. I know I got the probation right. Oh, go ahead. I'm sorry, sir. I didn't mean to cut you off.
No. Go ahead.
I said, I know I got the probation violation, but I'm just trying to handle some things because I'm trying to go to school as well. And I'm just wondering what's the weight on bond as far as setting the bond.
So this can be something negotiated between your lawyer and the district attorney where they can consent to a bond. It happens. I get them not all the time, but I get them on a pretty frequent basis where there have been agreements reached as it relates to bond. And I don't get between the parties. So if your lawyer and the prosecutor agree to a bond, I sign off on it.
Okay. Yes, sir. I understand.
Okay. Anything else?
No, sir. Thank you, sir, for your time.
You're welcome. Free to go back.
All right. Thank you, sir.
Okay.
Man. Oh. Hold up.
You are John Joseph Smith?
Yeah.
So you're charged one count of criminal trespass. Bond is going to be set at $1,000. Do you believe you can post that bond?
$1,000.
Yes. It's just basically $100, between $100 $200. There's going to be a preliminary hearing date set for February 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah. I want to ask you, am I going to be getting out pretty soon?
Yes. You're going to have to go through, well, you can either pay the entire $1,000 amount, or you can go through a bonding company and pay between $100 and $200. The paperwork will come across today. So the jail will probably, Sheriff's Department probably get that paperwork by 2 o'clock. Okay.
2 o'clock in the morning?
No, this afternoon. I do the paperwork. So as soon as I'm done here, I start on the paperwork, and it generally takes me about 2 hours to complete after the hearing.
All right.
Okay. You're free to go back, sir.
Take a seat, Mr. Smith. Just take a seat. Sebastian, yeah. Sebastian. Oh, no, go to the door. Yeah. Go to the door.
Mr. Smith, sir, you're charged with one count of entering an automobile. Bond is going to be set at $6,000. Do you believe you can post that bond? This is a felony offense, so you're going to have a preliminary hearing date set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Sorry, sir.
What did you say?
Do you want me to see if you qualify for the
I don't
appointment?
know what you're talking about. What's the bond? What was the charge?
I have no idea what he said.
I don't know what you said. The charge of anything.
Okay, let me start over.
Please.
You're charged with one count of entering an automobile. Bond is set at $6,000.
Okay.
Your preliminary hearing date is February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail.
Okay.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you did not fill out the form.
No,
Are you-
I don't know nothing about no. I didn't do it, but I wouldn't even do it. It's not even my. I wasn't supposed to be arrested. This ain't got nothing. I wasn't even in the plant. This is the coke can't pick up my house. I don't know nothing about these folks got going on. And I'm sick of this, like third time this shit happened. I'm tired of it. I ain't signed up to do shit they got going on. This not nothing with me.
Okay, is there anything else, Mr. Smith?
Are y'all here? This is a lie.
Yes, Smith.
I'm saying this is the first time they did it.
No.
What's the so how can I get out of jail? Like what's the thing like? How can I get pay the bond? Well, not pay the bond, but get the bond. But this, I don't know. You got $6,000. This is a lot.
Hey, leave your last off.
Mr. Snyder.
Did the judge dismiss you? Did the judge dismiss you? Answer the question.
This is some bullshit. I didn't do nothing that said that.
Hey, listen. First of all, put the mask up. Put the mask up.
Your Honor, you done, are you done with them?
Okay.
Yes.
Be quiet.
Yes, I'm done with him, but the allegation, just so he knows, is that an officer allegedly observed him going to vehicle at the airport, pulling on door handles, and the officer allegedly observed him open the door handle of a Jeep and caught him going through the glove box. So that's why he's here.
Okay, he heard everything.
Okay.
All right, next up, Mr. Snyder. All right, go, yeah.
Snyder, sir, you're charged with one count of simple battery. Bond is set at $3,000. One count of simple assault. Bond is set at $3,000. One count of cruelty to children in the third degree. Bond is set at $3,000. And one count of obstructing an officer. Bond is set at $2,000. So that's going to be a total bond of $11,000. Do you believe you post that bond?
Say that again, please, sir.
It's a total bond of $11,000. Do you believe you can post that bond?
I want to hear my charges one more time.
Okay. Simple battery, simple assault, cruelty to children in the third degree, and obstructing an officer.
How would I have simple battery and simple assault?
Okay.
I thought that was the same charge.
Oh, hold on. They're not the same. Simple battery is was touching someone without leaving a mark in an offensive manner. Simple assault is you don't have to touch the person. You just have to place them in reasonable fear of receiving an injury. So in your case, the simple battery is alleged to have occurred by you allegedly grabbing the hair of Miss Kochinski and pulling her by her hair. And it says that it was observed on security video footage. Simple assault is by placing Miss Kaczynski in reasonable fear of bodily harm. It says after pulling the victim's hair, you allegedly placed her in fear that you were going to hit her. That you committed the offense of cruelty to children in third degree by grabbing Miss Kochinski in the presence of a juvenile, last name McLean, by the shirt, then pushing her against the wall multiple times. Says that you and the alleged victim previously resided together and that you were in a relationship. Does that make sense to you now, sir?
Yes, sir, it does.
Okay. So your preliminary, there's going to be a stay away provision on the bond, a stay away from a Lashari Kochinski. Do you understand that?
Yes, sir. I had like two questions. What would that range out to be? What would the estimate be when I do place bond I just want
Approximately between probably $1,000 and $1,400.
okay. Is those misdemeanors?
Yes, sir.
Okay. And I wanted to ask one more thing. This is how much time do you think all that will hold all together?
I have no idea.
When I do my time.
For each offense, the penalty range goes from probation to a year in jail. These offenses can be run concurrently or consecutively, which means the maximum possible time is 4 years.
Yeah. If they ran consecutive.
Right.
Okay.
Right. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any other questions for me, sir? Okay, you're free to go back.
Thank
Mr. Spain, sir, you're charged with robbery by snatching, sudden snatching. That's felony. Bond is set at $5,000. Sorry. Simple battery, bond is set at $5,000, and financial transaction card fraud, which is a felony, also bond set at $5,000. It's a total bond of $15,000. You believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a Paula Nash. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
None at all, sir.
Okay, you're free to go back.
Stewart.
Ms. Stewart, sir, you charged one count of failure to have your headlights on. Bond is going to be set at $500. One count of an open container violation. Bond is also going to be set at $500. And one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. You're going to have a total bond set at $2,500. You believe you can post that bond?
I hope so.
Okay.
You make these phone calls.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, you said something, Mr. Stewart. I didn't catch all of it. Was that a question?
Well, I'm hoping I can get in touch with my member. I haven't been able to make phone calls or anything. I do have one question about the driving without the headlights. Is it possible, or that could be? I mean, I wasn't on the road 30 seconds. I just forgot to turn the headlights on. It wasn't like I drove a mile or two. I hit the road, and all of a sudden, the lights were on me. Police lights were on me.
My understanding is that there's not a time requirement as it relates to how long you're allegedly driving without your headlights on.
Right.
Okay. Anything else, sir?
I understand. Nothing else. Sir.
Okay, you're free to go back.
All right, thank you.
You're welcome.
Sorry, can you give me the total of that bond again, please? I'm sorry.
$2,500.
All right, thank you. We don't get all that. There's a wage. Let's take the.
Afternoon, y'all.
Good afternoon, sir. You're charged with one count of aggravated assault by strangulation. I've set the bond at $10,000. And one count of criminal trespass. I've set the bond at $3,000. Aggravated assault by strangulation is a felony offense. There's going to be a total bond of $13,000. You believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond. Stay away from a gelling weeks. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, because I think I have one on standby, but I may not.
Are you currently working, Mr. Weeks?
Yes.
About how much do you make per hour?
I don't get paid per the hour, I get paid per day.
Okay. Give me an average of what you think you make in a month.
In a month, 4,000.
Okay. You're on the edge, but I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. If you so desire to hire your own lawyer, just notify the lawyer from the public defender's office, and they will, so they can remove themselves from the case.
Okay.
Any other questions, sir?
Yes, sir. Could I get a reduced bond by chance?
No, I'm not going to reduce the bond in this case.
All right. And how much is the total bond again?
It is set at $13,000.
All right. Thank you.
You're welcome.
All right, up is Mr. Allen. He's a fugitive, Your Honor.
Okay. Mr. Allen, sir, you have the same rights and privileges as the other people that were here on this calendar this morning, but you're in sort of a slightly different posture. You are charged as a fugitive from justice. And what that simply means is that there is a warrant for your arrest out of the state of Illinois. And it says that it's condition release violation, which I'm assuming they're alleging that you violated some condition of your release. They've indicated that they want to extradite you back to Illinois to face these charges. You have a right to challenge that process, and you can demand a hearing to determine whether you are the person named in the warrant and whether this warrant actually reflects a valid charge. If you were to elect that option sometime between now and 90 days from now, there will be a hearing to determine those conditions. If the judge at that point determines that those conditions are valid, then your case, they'll sign off on the extradition paperwork, and Illinois will be notified that they have 30 days to come and pick you up. If they don't come and pick you up at the end of that 30-day period, they can request another 30 days for a total of 60 days for that process to take place. On the other end, if you believe you are the person named in the warrant and that you believe that this warrant does reflect charges that are valid, you can elect to waive your hearing. If you were to waive the hearing, you'd sign the waiver paperwork today. I would sign the paperwork today, and that 30 to 60-day window that I referenced earlier would begin running today. Do you have a lawyer representing you on these charges or these allegations up in Illinois?
Rather not here in Georgia. Can I ask a question?
Yes, sir.
So I actually signed this waiver, and I'm not sure I want a better understanding of this. I signed it in another state, so I'm actually out on the line and have to go to court for this extradition. I'm only here in Georgia for my son's health condition. I got pulled over, and my lawyer did tell me to keep a paper, but I actually forgot the paper. Actually, back yeah, he told me to keep a paper with me. And I actually just misplaced the paper and bring it with me outside to where I was headed. I got pulled over and they told me that I had a warrant, but I was also aware of it. And I told them that I have a paper that I'm out and I have to go to court on this extradition as well in another state. And I don't know, I want to better understand, I don't know if I can sign in 2 states or how that goes, but I do have court on this extradition in the following weeks from where I'm from.
So the short answer is yes, you can sign. If you were to contact your lawyer,
which I haven't had a chance to do yet either.
Right. What I was going to say is this. I actually had a person in a similar situation as yours yesterday. that they were wanted out of Texas. And there was a person last week that was wanted out of California. And both of them were able to get their lawyers in Texas and in Illinois to address the issue. And both of them were released within a day.
Okay.
So if you can get in contact with your lawyer in Illinois, have your lawyer to send the appropriate paperwork that reflects that this warrant, and I'll give you the warrant number. You have something to write with?
Yes, I do, man.
No, don't write on there.
No, hold on. Right?
No, we,
Right on the knuckle.
All right. Yeah. I'm ready for it, Your Honor.
Okay, it is W 541 689 275.
Okay, and this is the warrant, correct? The warrant number?
That's the warrant number that's listed in the paperwork that I have. If your lawyer were able to get the information, the documentation to show that this has either been lifted or that hold on, calm down for a second. Whether it's been lifted, that they're not gonna seek to extradite you, or that a bond has been paid such that you can be released. They provide that information to the sheriff's department, and they will release you. As I indicated before, we have no interest in your case.
Thank you, Your Honor. So,
You're welcome. Anything else, sir?
yeah, just to make things clear, should I talk to my attorney first before signing this waiver here?
If you feel that it's necessary, now the waiver is not an indication of guilt.
Okay.
The waiver simply says, I'm not gonna fight this. You can come get me.
Yes.
And in some instances, a person signing the waiver actually strengthens the hand of the lawyer in the other state, because Illinois knows that they're on the clock to have to either come and get you, or you're going to be released.
Okay.
And with the COVID stuff that's going on now, what I am just observing is that most jurisdictions they're not willing to put their people on the road to travel if there's another way. So it just simply says violation of bond condition or violation of conditions of release. So if you were charged with murder, armed robbery, aggravated assault, I'm certain that they will expend the money to come get you. But for some lower level felonies or really lower level felonies, I don't see a desire by and large to put people on the road.
Thank you, Your Honor.
Okay. All right, sir. Once you sign that, if that's your desire, you'll be free to go back.
Yes.
All 7 copies right there.
All of them?
Yes, sir. You can just take a seat.
Thank you, Your Honor.
State your name.
Bradford.
Okay, Miss Bradley, we're gonna have to bring you back. Well, I'm gonna place you back at the end. There was a notation that they were unable to locate your file when I received the paperwork this morning, and I still don't have the warrants for you, or warrant. This is a misdemeanor criminal trespass, and you're entitled to bond on this. But I still need to be able to look at the warrant. So I'm going to ask the deputies to just place you back, and I'll bring you back at the end of the ladies. Miss Davis, or Davis Francis.
Oh, dude, I meant to send you an email and register her, but she COVID.
Okay. Well, I think you may have. That sounds familiar to me.
If I did, I'm pretty sure Deputy McKenna did.
Okay. So what I'm gonna do with her is I set wow. Okay, so she has a bond set, but there's also a stay away provision on the bond. And I think, well, I not think I know, in order for the stay away provision to be valid, I have to address her directly. So I'm just going to do a continuance order for her to bring her back before me tomorrow.
Yes, sir.
Okay, thank you. Ms. Freeman?
Jennifer Freeman, yes.
Ma'am, you're charged with one count of driving a vehicle with no insurance. The bond is going to be set at $1,000, and one count of, it says, knowingly driving a vehicle with a suspended or canceled registration. Bond is going to be set at $500. So that's a total bond of $1,500. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions of me?
No. Thank
Okay,
you.
man. You're welcome. You're free to go back.
Bye, King.
Okay, Ms. King, ma'am, you're charged with one count of violation of Georgia Controlled Substance Act. Bond's going to be set at $3,000. Do you believe you can post that bond?
Maybe.
Okay. Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201, because this is a felony offense. If you're able to bond out, that court date will get waived, then you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working, ma'am?
No.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay,
You
ma'am.
said you said the court date was February 7th.
Yes, 7th. But upon bonding out, that date, as they say, by operational law, that date gets changed, and you will get a new court date in the mail.
All right, thank you.
Okay.
You can step out. Step up.
Ms. Parker?
Yeah.
Ma'am, you're charged with one count of criminal trespass. Bond is going to be set at $1,500. And one count of obstructing an officer. Bond's going to be set at $2,000. These are both misdemeanor offenses. There's a total bond of $3,500. Do you believe you can post that bond?
No, sir.
Did you say no?
No, that's a lot.
Okay.
How
There's
much
going to
is that
be,
actually?
hold
Talk to
on.
first man's question at the end.
Yes, ma'am. At the end, you can ask me whatever question you want to ask me. There's going to be a stay away provision on this bond to stay away from an Alex Brown. Do you understand that?
Yeah.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Now, would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No, but I received a monthly check.
Okay, so yes or no?
No, I'm not working.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was it that you wanted to tell me?
The bonds being set that high, how much do I really have to pay?
Approximately $300.
Okay, I can do that.
Okay. Is there anything else, ma'am?
At the preliminary hearing, is that where I go to plead guilty or not guilty?
No. If you bond out, that preliminary hearing date is waived by operational law, and you'll get a new court date in the mail. So what happens is that once you bond out, your case goes out of magistrate court and it goes to state court. because I don't know what judge will get your case and what calendar that judge has, I can't tell you about court dates for that judge's calendar. And because that judge is an unknown right now, we can't tell you what date will be your true next court date. Okay? Anything else, ma'am?
No, thank you.
Okay, ma'am, you're free to go back. Miss Williams, ma'am, you've been charged with 1 count of affray and 1 count of criminal trespass. There's going to be a $1,000 bond set on the affray charge, and I have dismissed the criminal trespass charge. So you're going to have a total bond set at $1,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions of me, ma'am?
No.
Okay, you're free to go back.
Thank you.
Yeah, we're bringing Bradford back up now. We're gonna wait.
Let's bring Miss Bradford back up. Okay, ma'am. You are charged with 1 count of criminal trespass. This is a misdemeanor charge, which means that you are entitled to a bond by law. I don't have the warrant before me, so I cannot make a pinpoint determination as to what I believe is the reasonable bond. Generally, on criminal trespass, where you're at a place where you've been told not to come back to, I generally set a bond of $1,500. If you destroy another person's property, break their cell phone, punch a hole in the wall, destroy the door, I generally set a bond of $3,000. And I would most likely put a stay away provision on the bond. Because your paperwork is somewhere floating out by no fault of yourself, I am going to, unless you have an objection, I'm going to sort of split the baby, and I'm going to set a bond of $2,000. And I'm setting that bond so that you will be able to bond out. Without having the warrant, I may be placed in a situation of having you in jail another night while we try to locate the warrant. I have no doubt that this warrant will get found and located, but I'm not going to have you sit in jail because of that. So I'm going to set a $2,000 bond. So you now know that you can contact bonding companies or whomever to help make the arrangements for you to get out of jail. Do you have any objection to my doing that?
No, sir.
Okay. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, ma'am?
Yes, sir.
About how much do you make per hour?
1350.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
That's it. Email, John.
Okay, thank you for your assistance. Have a good day.
Yes, sir. Thank you.
All right, let's switch over to the mail side.
Mr. Allridge. We're gonna start with Mr. Brown, Your Honor. Mr. Allridge, you stepped out to use the restroom.
Okay. Mr. Brown.
Good morning,
Good morning, sir. You're charged with one count of theft by receiving stolen property. This is a misdemeanor offense. Your bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, Your Honor.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, Your Honor, I have a retained attorney.
Okay. Do you have any questions of me?
Yes, Your Honor. If you would consider, I just bonded out of Cobb County on a $45,000 bond, and having paid that bond, I wanted to ask if you would consider granting me a signature bond. I would be prepared to show up to court and handle all of the charges at hand and show up to all of my court dates with my retained lawyer. But I missed the birth of my son on December 5th, and I was also incarcerated for Christmas, so I just was gonna take the risk and ask you if you would consider that.
No, there is no problem in asking, but I'm not going to grant you a signature bond. Okay. All right, sir. You're free to go back.
Bo.
Mr. Bowe, sir, you're charged with one count of forgery in the third degree. This is a felony offense. I've set a bond at $10,000. Do you believe you can post that bond?
What?
$10,000. Do you believe you can post that bond?
No, sir.
Okay. Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Are you currently working, Mr. Bowe?
Yes, sir.
About how much do you make per hour?
$10.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Mr. Ulrich.
Mr. Aldridge, sir, you're charged with one count of criminal damage to property in the second degree. This is a felony offense. Bond is going to be set at $5,000, and one count of simple battery, family violence. Bond is going to be set at $3,000. So that's a total bond of $8,000. Do you believe you can post that bond?
Yeah, yes, sir.
There's going to be a stay away provision on the bond to stay away from a Shade Fowler. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah,
Are you currently working, sir?
yeah, work for Walmart.
About how much do you make per hour?
I make $22 an hour.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, that's my daughter, who you said that the victim, but my wife is pregnant. So
Okay,
she's 8 months pregnant. So I'm trying to get back home to my wife.
okay,
I'll be able to make the bond today.
okay.
Okay, sir.
All right, you're free to go back.
Thank you so much.
You're welcome.
All right. Mr. Coburn.
Mr.
Coburn.
Mr. Coburn, sir, you charged with one count of violation of Georgia Controlled Substance Act. I've set a bond at $3,000 for that offense, and one count of obstructing an officer. I've dismissed that count. So you're going to have a total bond set at $3,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Are you currently working?
No, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back.
Thank you.
Jenkins. Jenkins.
Mr. Jenkins, sir, you're charged with one count of failure to have your headlights on. Bond is going to be set at $500 for that offense. One count of use or possession of drug-related objects. Bond is going to be set at $1,500. And one count of simple possession of a controlled substance. Bond is going to be set at $3,000. So that's a total bond of $5,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. Sir, I'm a veteran, and I need to know if y'all have veterans court or veterans attorney through Clayton County.
Judge Robert Mack in Superior Court is trying to get a veterans court started. If you want me, I will refer you to your case to his assistant for them to determine whether you qualify.
Okay, and then the other question is, I have 2 major surgeries coming up. One in 4 days, my right kidney is being removed. And then 2 months later, I'm having a total right hip replacement. So I will not be able to go in and make any court dates.
So currently, if you bond out today, you're probably not looking to another court date for another probably 5 to 6, maybe 7 weeks. I don't know.
Okay, so if it comes up between one of my surgeries, I don't want to violate my bond and stuff by bonding out and then not be able to go to court.
Okay, so I've appointed a lawyer to represent you. I know you don't know who that person is right now, but it's going to be someone from the public defender's office here in Clayton County. And you need to stay in contact with your lawyers as to whatever is happening with your life.
Right.
Okay? All right, sir. You're free to go back.
Mr. Johnson. Yes.
Mr. Johnson, sir, you're charged with one count of driving in a vehicle without a valid license. Bond's going to be set at $1,000. And you're charged with one count of possession of more than an ounce of marijuana, but it actually, the amount that they've listed in the warrant is less than an ounce, and one count of possession of a controlled substance. I did not see sufficient evidence for those 2 charges to go forward. So those 2 felony charges are going to be dismissed, and you're charged with one count of use of possession of a drug-related object, which is a misdemeanor. Bond is going to be set at $1,500. So you're going to have a total bond on these misdemeanors set at $2,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
$15 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you.
Okay, you're free to go back.
Mr. Lewis.
How you doing, y'all?
Mr. Lewis, good morning, sir. You're charged with 1 count of homicide by vehicle in the 2nd degree. This is being charged as a misdemeanor. I've set a bond at $10,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes.
About how much do you make per hour?
15 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Mr. Marcus.
Mr. Morris, sir, I'm sorry, Mr. Marcus, sir, you're charged with 1 count of criminal trespass, damage to property is being written as a misdemeanor. Bond's going to be set at $2,500. Do you believe you can make that bond?
No, sir.
There's going to be a stay away provision on this bond, to stay away from a Jakarta Lions. Do you understand that? I'm sorry, sir.
Can't make fun, sir. I won't be getting out no time soon.
Okay, we're on to the next question. There's a stay away provision to stay away from a Jakarta Lions. Do you understand that?
No, sir.
What do you not understand?
That's why I been running.
I'm sorry?
Yes or no? Yes or no?
No, sir, I don't understand that, sir.
Why do you not understand a provision to stay away from Jakarta Lions? What is that about that that's confusing?
Because I don't have nowhere else to go. That's the only place I have to go. That's the only thing I'm saying, sir.
Okay, so Mr. Marcus, during the pendency of this case, unless this stay away provision is removed, it's going to remain in place. So if you were to call Miss Lyons from the jail, that could constitute a felony of aggravated stalking. And sir, I'm not asking you to agree with me. I'm just trying to inform you. You can act accordingly. You can do, you're a human being in the United States of America. You can do whatever you want to do, but there are consequences to actions. My job as a judge is to make sure that you understand that if you decide to disregard what I've said, when the consequences come, you can't say, I didn't know. So do you understand that if you go around Miss Lyons, if you contact Miss Lyons, while this provision is in place, you will receive a felony offense. Do you understand that?
No, sir.
What do you not understand about that?
That's what I pay my rent.
Sir, that's not a response. What it sounds like you're saying is you don't like that. You don't like it because I pay my rent there. So I don't like the fact that I can't go back there. That's not what I asked you. I said, do you understand if you go back there, you're going to get a felony charge and you're going to be in custody until your trial? It's up to you. You can stay in jail as long as you want to. It makes me know, never mind. My job is to make sure that you understand. And so, sir, this is being recorded, just so you know, so that if you decide to do what you want to do and you say the judge never told me this and the judge never told me that, this recording comes out. So it's your life. You get to live it the way you want to live it. And if it wants to be in an orange jumpsuit in the Clayton County Jail, God bless you. Have at it. My job is to try to make sure that you understand. So I believe that I've said it now 3 or 4 times. I'm going to move to the next point. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. If you're able to make bond, that date will get waived and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Yes or no? Okay. All right. Is there anything else, Mr. Marcus? All right, sir. You're free to go back.
Your Honor, can you repeat, Mr. Aldridge's total bond again?
Yes, $8,000.
Okay, so the whole total, right? Yeah, I appreciate it. Thank you. Ms. Murphy. Okay.
Mr. Murphy, sir, you're charged with one count of driving a vehicle on an expired or invalid tag. Bond is going to be set at $500. One count of having a child that is not restrained in a child seat. Bond is going to be set at $500. One count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And one count of possession or use of drug-related objects. Bond is going to be set at $1,500. So you're going to have a total bond set at $4,000 for these 4 misdemeanors. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, I'm okay.
Okay. Do you have any questions of me?
I get that child restraint, ain't got no child.
Okay. So the allegation is
Is that on?
No, you ready?
Oh, that's on.
you know what? It's a seatbelt violation. On the bond order, it says child restraint violation, but it's a seatbelt violation. Okay, any other questions? Okay, you're free to go back.
Mr. Ross. Weston Giovanni Ross.
Okay, Mr. Ross, sir, you've had a busy year. Possession of disposed or vehicle. Let's see, how are they writing this? Felony attempting to conceal the identity of a vehicle. Bond is going to be denied on that charge. Possession of a firearm during the commission of a crime. Bond is going to be denied on that charge. Theft by receiving stolen property. Bond is going to be denied on that charge. Concealing the identity of a vehicle through the tag. Bond is going to be set at $500. Speeding. Bond is going to be set at $500. And improper lane change. Bond is going to be set at $500. So you're going to have 3 counts with no bond and a $1,500 bond on the 3 remaining counts. You're going to have a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for February 11th at 8:30 in the morning. Do you currently have a lawyer on your other offenses?
No, sir. I'm not questioning.
Okay, so do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify, Mr. Ross. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
Yes, sir.
Now, like with those charges, that truck didn't belong to me. It was my boss's truck. And how could I go about having him come up here to admit the ownership of it, because that's what we were supposed to do.
Okay, so this is where the lawyer comes in, and the lawyer becomes a person, or the investigator becomes a person that works through this. If you're able to show that the owner of this vehicle is not you, then that could go a long way in having those 3 charges dismissed. However, given the fact that the identity and all of this stuff was kind of hidden, it may be difficult to be able to show that.
The truck was only in my possession because I was during work. I was at work. I was just driving at work. And I was just trying to figure out if there was anything I could get a bond for that, because I do need to get out to get my job.
Well, it appears like this is the 3rd time that you've been arrested this year. So that becomes an issue as to why the bond is being denied. It's not because this is the crime of the century, but it appears as though you're just going to keep coming back to jail. So if you're going to keep coming back to jail, maybe you just need to stay in jail.
I understand, but this time it wasn't my fault, is what I was saying. It's not under my conditions. That truck doesn't belong to me. I just went to work, and I do have my boss to admit that.
And believe me, if that information is before me, these charges will be dismissed and you'll be out on the street.
I'm saying, is there any way I can get him to get in contact with you somehow? Was it too late?
Well, yeah, it's kind of it's never too late. Did you tell the officer that this wasn't your vehicle and it was your boss's vehicle, and gave the officer the contact information to contact?
He didn't want the contact information. He just told me tell him to come to court.
Okay. So, Mr. Ross, you have to, in my opinion, understand that, like I said, with 3 arrests this year, you're not looking to be a pretty, credible person. Stuff happens, right? But your word is not going to be worth as much if you had not been in a situation where you have been arrested 3 times this year. Does that make sense to you? It's like, the best way I've heard it explained to me is like, if you cheat on your girlfriend and she takes you back, she still is not going to forget the fact that you cheated on her. And you come home late, and you could have been handing out winter coats to homeless people. She's gonna, in the back of her mind, think, was he with that woman again? So it just brings into question things that ordinarily would not be brought into question. So that's the lens that I'm viewing this through.
I understand. Is there any way possible that I can have this evidence brought to you? Because, Your Honor, I can't sit here until the 11th. I got priorities and children.
I understand. So the lawyers, and this will be in the public defender's office. We're doing preliminary hearing calendars every week. And I'm not doing preliminary hearing calendars next week. I'm doing preliminary hearing calendars the week after that. But every week there are preliminary hearing calendars that are going on. And if there's something that's brought up, I sign stuff all the time for cases that are set 3-4 weeks out, where they've reached an agreement on something. So the short answer is that you don't have to sit here, but there's going to have to be some proof to show that what's in here is just patently incorrect, and you're just being basically the person that's held accountable for somebody else's misdeeds.
And I will go about doing this by having them go to the public defender's office.
It's the public defender's office, and again, if your boss is willing to say, "Hey, no, he was driving the car," He can sign an affidavit to that effect.
Okay. Thank you, officer. I mean, thank you, Judge.
Okay. All right, sir. You're free to go back. Mr. Schuler, is it Schuler?
Yes, sir.
Sir, you're charged with one count of simple battery. Bond's going to be set at $3,000, and one count of cruelty to children in third degree. Bond's going to be set at $3,000. These are both misdemeanor offenses, so that's a total bond of $6,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond, stay away from a Rich Marie Otero. Do you understand that?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, but I have a question, sir. Oh, what I was charged, they said I was only charged with third degree of cruelty to children. I didn't know I had a battery charge, sir.
A simple battery. So, I don't know why they would say that. The way that the child cruelty in third degree is, the way the statute is written is that you knowingly allow a child to see an act of violence. So if they're charging you with child cruelty in third degree, that you allow the child to see an act of violence, how can they not charge you with committing the act of violence?
Right, okay, sir, but then, yes, sir.
Okay, so would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir, I am.
About how much do you make per hour?
15 an hour, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions, any other questions for me?
No, sir, I do not.
Okay, Mr. Wilkins, you're free to go back, Mr. Schuler.
Wilkins.
Mr. Wilkins, you're charged with one count of theft by receiving stolen property being a motor vehicle. Bond is going to be set at $10,000 for that offense. And one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. So that's total bond, $11,500. Do you believe you can post that bond?
One quick question, what's the percentage on 60%?
Yes, sir.
On the $10,000 bond, what would be 60%?
You're looking at anywhere from $1,000 to $1,500.
Okay.
Roughly.
The debt, I'm not sure if I better afford that or not. I'm listening to the chart. But well, I know I can bond out on possession, but with the $10,000 bond, I make a couple phone calls and see if somebody be willing to help me make that bond. But as of right now, no, sir, I will not do that.
Okay. You're going to have a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Are you currently working?
Yes, I work 2 jobs.
About how much do you make per hour?
The first job is 16 and the second one is 14.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
Other than being on our part, that would be the only question I have. But I understand if you say no, if you give me a no, and I understand that because I put myself in this position and I have to get myself out. But I was going to ask you that question. I do have to get back to my job as soon as possible. But I understand if you say no, because like I said, I did put myself in this position and I have to get myself out.
Okay. And I was going to say no.
Okay.
Okay, sir. You're free to go back.
Okay, thank you. Have a good day.
You're welcome. Is it Mr. Gabriel?
Yes, Mr. Gabriel, he's coming up.
Gabriel. Mr. Gabriel, sir, you have the same rights and privileges as everyone else that I mentioned before, but you're in a slightly different position. You're here on what's called a fugitive from justice warrant. And what that simply means is that there's a warrant for your arrest out of another state. And in your case, it looks like it's Harris County, Texas, that they have a felony warrant for, looks like the charge is criminal mischief. And they've indicated that they will extradite. So when you're arrested on a warrant like this, you have the right to contest this warrant or extradition process, for lack of a better term. And what that means is that if you believe that you're not the person named in the warrant, or you believe that the warrant alleges a charge that is non-existent or is no way that that could happen, you can request a hearing. And if you request a hearing for the judge here in Clayton County to look into that, sometime between now and the next 90 days, you will have a hearing. And at that hearing, it's not going to be a situation where there's a termination of your guilt or innocence. It's just going to be whether you're the person named in the warrant and whether this warrant actually exists. If after having the hearing, the judge determines that those conditions exist, the judge will sign off on the extradition warrant, and then the state of Texas will have a 30-day period to come and get you, up to a 60-day period if they request a 30-day extension. If you believe that you are the person named in the warrant, and if you believe that these charges are possibly credible charges, not that whether you're guilty of it or innocent of it, but that these charges exist, you can waive that 90-day period to have the hearing and say, I want the clock to start ticking today. If you were to waive that hearing, the clock would start running today. The state of Texas would have 30 days to come and get you. They can also request an additional 30 days as if in the other scenario. And whether that's granted or not is something that is within the total purview of the sheriff's department. Do you have a lawyer representing you in Texas on this charge?
Yes.
Have you spoken to that lawyer?
Not since last month. I haven't. Maybe it's the holidays, but my last. I had COVID last month, and I was in a hospital, and on account of that, I missed my hearing or my appearance in court. That was December 9th.
Okay.
But I was sick with COVID, and I have it documented.
Let me ask you this. As this just happened last week with a person who had a warrant for his arrest out of California. He had lawyers representing him out in California on the charge, and there was a preset bond out there. His family was able to make the bond, and they sent the information over to the sheriff's department, and that person was released. Do you have any idea whether there is a bond set in Texas on this?
Well, initially, I paid. I think it was I believe a $15,000 bond. I believe it was 15,000.
Okay.
And and my family helped me post the bond. Is that what you mean?
So, let's see. I am going to. Today is Wednesday. I'm going to be doing first appearance tomorrow. And I will be around on the 31st, even though I don't have a calendar. Do you believe you can get in contact with your lawyer in Texas? Uh-oh. Okay, looks like We're gonna have to wait for them to come back on. I'm gonna stop my video and audio. So it's just like I've gotten a new computer. So all of my settings, everything that was saved, I just tried to click on the YouTube, which is normally saved, but I had to enter the. So it's just like I've gotten a new. Hold on. So all of my settings, okay. So I apologize for that delay. All right, so Mr. Smith and Ms. Pittman Smith, you have taken advantage of the opportunity to hire Mr. Fortis as your lawyer. Mr. Fortis, for your benefit, I have reviewed the warrants and the criminal histories for both of your clients. Mr. Smith has, I think, 1 arrest, and Ms. Pittman Smith has maybe 3 arrests, prior arrests before this. So they both have relatively light criminal histories. I'm going to point you in the direction of what I'm thinking of, but I'm going to give you the opportunity to say whatever you want to say as it relates to your clients. It seems like they're both eligible for bond. My biggest concern is the amount of narcotics that was in the residence. So I'm inclined to grant them bond. The number is going to be, I think, the biggest issue, but I will listen to you as to whatever you want to tell me about your clients and these charges.
You ready, Judge?
Yes, sir.
Okay. So, Judge, I'll start with Miss Pittman Smith. She is 34 years of age. She has been married to Mr. Smith. They've been married for approximately 1 year. She's been in Georgia since 2005. She works at Walmart. She's a manager at the Walmart on Old National. She's been there employed there since 2015. They have no biological children together. She's not on probation. I don't know about the 3 arrests. I'm not sure if there are any convictions. I do believe, like the court, that I do believe that she meets the IALA requirements for bond. The reason why, Judge, while you're looking at the number of narcotics, I think the majority of that has to do with some vape cartridges, and I think that what they did is, and I'm not 100% sure, but my suspicion is that they've taken the THC cartridges or vape cartridges, whatever you want to call them, and then they've charged those individually. While there may be a couple of other charges, I think it's all marijuana related. So while on paper it doesn't look very good, it looks like it, from my vantage point of what I know, it looks like a little bit of piling on. But I believe it's just marijuana related. So that would be my argument for Ms. Pittman Smith. And I'm not sure what number the court is thinking about, but what I was thinking of was a $5,000 bond on all charges.
Okay. I wasn't thinking that number. So I'll tell you generally how I think. If you have what's listed in the affidavit is 35 THC pens, 15 bags of green leafy substance, 14 bags of THC edibles, and it says altogether about 5.74 ounces. Now, I understand what you're saying about the parceling it out, and I don't necessarily disagree with that. But with what I see, it looks like this is sort of the allegation can be made that this is a business.
Let me say one other thing, Judge, and I certainly don't mean to interrupt you, but this is a crucial point to this, but I really don't like to get into the facts at this point. But Mr. and Miss Smith take care of Miss Smith's stepson, and how all this came to be is that Mr. Ruiz, who is the stepson of Mrs. Pittman Smith, they were trying to help him. He has I would say some mental.
Schizophrenia, right. And he
Okay,
had been
and
released
so-
from Southern Regional, and he's the
Correct.
one that made the call. And I
But-
understand that.
And a lot of the marijuana that you're referring to was in his room. But that's an argument for a different day. And my understanding is, and I've spoken to her parents about this, that he was subsequently arrested for smoking marijuana at a Walmart where they got him the job, along with terroristic threats. My understanding is that he may have already made bond on those charges. But as the facts unfurl a little bit, I have a feeling that that's what's going to come out. I know that's not an argument for here, but it's just my argument for the court to consider something significantly less than maybe what the court is thinking with respect to bond.
And I'm happy to have the conversation. So the allegation, as I read, was that as it started, the allegation is that Mr. Smith had a garbage bag that contained marijuana, 3 ounces maybe of marijuana, and he was taking it out and placing it in garbage. Now, if I take your argument and carry it out, if Mr. Ruiz is the person that made the phone call, the drugs were in his room, it would seem to me that a reasonably prudent person would say, hey, all of this stuff belongs to him. It doesn't belong to us. This is his room. And that may have not led to an arrest. I don't know. I can't, as this discussion only fits as to what is a reasonable bond. Okay.
Understood.
So it's not about whether they are convicted or whatever, but all right. So is there anything else, Mr. Fortes?
I mean, only in consideration that, obviously they were to be working quite a bit over the holidays and they've missed that. And so they've had to inform their employer to take a leave while they can try and get out without losing their jobs and their managerial positions. Other than that, nothing else.
Okay. So I have to set a bond for each offense or they're not going to be able to get out.
Understood, Your Honor. Thank you.
Okay, so for Ms. Pittman Smith, first warrant charges her with possession of firearm during the commission of a crime. I've set a $4,000 bond for that. The second charge or warrant is manufacture, violation of Georgia Controlled Substance Act, manufacture, sale, distribution, or delivery of a controlled substance. I've set a $10,000 bond for that. Possession of drug-related objects, bond's going to be set at $1,500. Possession of Schedule I controlled substance, bond's going to be set at $3,000. Second count, possession of Schedule I controlled substance, bond is also going to be set at $3,000. The VGCSA manufacture, sale, distribution, deliver controlled substance, bond is going to be set at $10,000. Possession or possessing the substance to manufacture a controlled substance, bond is set at $2,000. And for the second count, bond is also going to be set at $2,000. So by my math, that's a total bond of Did you say that that's high?
Well, I was thinking about, I was adding it up. I apologize. I thought it was a little high, but higher than what I expected, but that's okay.
So
But
Mr. Fortes.
Yeah.
Okay, sir. First, you're appearing without a tie on, and I've tried to look that over. If you're going to be making comments about my decisions, then I may need to start making comments about you. Okay, sir.
I understand, Your Honor. I didn't mean any disrespect. It was just my opinion, but I certainly respect the court's decision. I'm not disagreeing with the court. I was just kind of adding it up as I was going in my head, but I understand the court's position. I apologize.
Some may view it as a low-level sign of disrespect for the court.
I understand, Your Honor. But I didn't mean that, and I want you to understand that. I apologize. I'm grateful that Your Honor is inclined to set a bond.
And I reset the case so that you could be present.
And I understand that, Judge, and I didn't get retained until, the last minute, and that was not why I was there. So I was not present for any other reason. So I apologize, Your Honor.
Okay, so it looks like my total bond is $31,500 for Miss Pittman Smith. And you can check the math, but it's on the bond order.
That's correct, Your Honor.
And for Mr. Adonis Smith, the total bond by my math is $37,500.
And Judge, and the increase on that would be which warrant on that?
Well, he has more charges.
Understood.
So he has the tampering with evidence.
Right.
And I set the bond at $2,000 for that. And I'm sorry, I didn't announce the bonds. For manufacture, sale, distribution of controlled substance bond is set at $10,000. Possession of Schedule I controlled substance bond is set at $3,000. Manufacture, sale, distribution, deliver a controlled substance bond is set at $10,000. Possession of Schedule I controlled substance bond is set at $3,000. The manufacture, sale, distribution, and of controlled substance 2 counts bond is set at $3,000 for each of those counts. Possession of a weapon during the commission of a crime bond is set at $4,000. Use or possession of drug-related objects bond is set at $1,500. Tampering with evidence bond is set at $2,000.
Thank you, Judge, and I appreciate that. And I would, just for the record, I would adopt the same arguments other than the background information for Mr. Smith as well, for time's sakes.
I understand. I think Ms. Pittman Smith had prior trafficking of cocaine arrest. The preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon their bonding out, and they will receive a new court date in the mail.
I appreciate that, Judge. And again, I was just kind of adding it up in my head, but there was certainly no intent of disrespect to the court. I apologize for that.
Yes, sir.
And may I ask the court one other question, please?
Yes,
there was
sir.
another matter. I was waiting on my client to arrive in the Clayton County Detention Center, and my client's family called and said that he was there. I just want to make sure he's not on this morning. His name is Bernard Arnold.
Mr. Arnold is not on the calendar today. No, he's not on the calendar today. If he's in, depending on when he came in, he may be on the calendar for tomorrow. That'll be Judge Stephen Knights will be presiding over the first appearance calendar tomorrow.
Well, Judge, thank you very much, and I appreciate it. Thank you.
Okay, these bond orders will be entered later today. You're free to go, sir. Miss Pittman Smith and Mr. Smith, you're both free to go back.
Thank you.
Let's bring up Mr. Bush for Mr. Florio.
Good morning, Your Honor.
Good morning.
I apologize for being 2 minutes late, Judge, and I'm not saying this to be contrary, but it was because I did not have a tie or a coat on. And that's why I logged in at 11:02, Your Honor. I promise you, I was in a mad dash to make sure that I was respectful of the court.
I do appreciate that. And I try not to be a person that takes that as sort of a hard and fast rule, because things happen. But I think at some point, the comment about Oh God, that's high is just a little too much for me to take.
It was certainly not professional or appropriate for a courtroom setting.
No, Mr. Bush, good morning, sir. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm going to be presiding over this hearing. You've taken advantage of the opportunity to hire a lawyer, Mr. Florio. So normally I would speak to you, but I'm going to speak to Mr. Florio directly. But I want to caution you that this is not a private setting, so don't say anything you wouldn't want the whole world to know. Okay, sir? So, Mr. Florio, your client is charged with 1 count of possession of firearm by a convicted felon. I have not weighed in as to bond on this. I would like to hear from you as it relates to your client. I believe he has a prior conviction of armed robbery and aggravated assault.
He does, Your Honor. Mr. Bush has one prior conviction in life, one prior felony conviction, in life. He was 16 years old and arrested and charged as a juvenile with that armed robbery here in Clayton County. Obviously, even though he was a juvenile at the time, the case was transferred to Superior Court and he was prosecuted before the Honorable Judge Benefield. At 16 years old, he did receive a 12-year prison sentence, obviously of which he did every single day. He was released 3 years ago, and since then has largely worked to try to turn his life around. He does have another arrest for which he received misdemeanor probation from the Honorable Judge Mack, but he is not on he's not on probation at this time. It was a misdemeanor sentence from the Honorable Judge Mack, 18-month misdemeanor sentence, I believe. As I understand it, and obviously I'm kind of working secondhand, I've had contact with many of his family members. His brother reached out to me. I've known Mr. Bush and his brother and other family members now for the last 3 years. His brother reached out to me last night, as did other family members, in concern to Mr. Bush's arrest. I believe that he was arrested in an auto. There was a traffic stop conducted. I believe it may have been based off of a window tint violation. I believe Mr. Bush was the front seat passenger in that car. From what I understand, there were 5 individuals in the automobile. There were 2 firearms located. What I've been told is that there was a female in the back of the car who claimed ownership of one of the guns that may have been in a purse or something of that nature. I believe there was a second firearm located in the back seat of the car, and everyone was charged. There may be an allegation that Mr. Bush took ownership of that gun. His brother believes that there may have been that allegation. If that's true, I've known Jarvis Bush now for 3 years. Jarvis Bush wouldn't agree that today was Monday, let alone that there was a gun in the car that was his. I mean, he did 12 years to the door in an armed robbery case. There's no way I believe that this young man would have ever said that any gun located in any car was his. He was not the driver of the car. He was not the owner of the car, and the gun was not found on his person. Obviously, and I know the court knows this law better than I do, certainly. But obviously, the owner of the car is presumed to possess what's in it, as is the driver of the car. And Mr. Bush was neither the owner nor the driver. It was just an automobile. It was a firearm, as I understand, located in the back seat of the car. There would have been 2 young men in the front seat, Mr. Bush being one and the driver being the other, and 3 young ladies in the back seat. Certainly, we'll be prepared to address these charges before the Honorable Judge Mack when this case goes to Superior Court. We would ask that bond be set in this matter. He does live in Union City. He has 2 twin boys. They're 2 years old. They turned 3 in May. He lives with his children. His children and the children's mother all live together in Union City. He's actively employed by a moving company here on the south side of Atlanta. I would ask that bond be set in the amount of $5,000. I think it takes into consideration, I understand he is a convicted felon, and I understand he certainly has been convicted of a serious charge. And I certainly don't mean to minimize that, but he was 16 when he did it, and he did it. He pled guilty and was sentenced. he was 16 when he did it. And oftentimes the decisions we make at 16 are a lot different than the decisions we would have made when we were older. He certainly paid the price for that, having spent 12 years, almost his entire 20s in the state prison system. And I've talked to him a lot about that, and it certainly changed him growing up in the state prison system. But he's done a lot to try to rehabilitate his life and turn his life around, and really dedicated himself to family. So I would ask for a $5,000 bond. I think that's a bond that his family has a realistic shot at making, Your Honor.
And I will, for the record, take into account the circumstances under which the firearm was located, as you have outlined in your argument. I don't believe that $5,000 is unreasonable. I will let you know, Mr. Florio, and you don't have to comment on this, but in the warrantless arrest affidavit, there was a notation that your client was allegedly convicted of possession of methamphetamine on January 14th, 2019, but that does not show up in his criminal history. So I'm not taking that into account, but that's something that you may want to look into.
And Your Honor, just for the record, I'll look into that, but I don't believe that is accurate. He was arrested, but I believe that the Honorable Judge Mack sentenced him to 18 months of misdemeanor probation. It was out of the Superior Court of Clayton County.
Okay.
And so I don't believe that's accurate. I believe he was convicted instead of something else. I'll double check that. I did not represent him. He was represented by their counsel. So
Okay.
If I'm wrong, it certainly is not an intentional misrepresentation to the court, but I don't believe that's accurate.
I understand. Okay. Well, I'm going to set bond at $5,000. Is there anything else, Mr. Florio?
No, sir. Thank you very much for that consideration, Your Honor.
You're welcome. You are free to go, and Mr. Bush, you're free to go back.
Thank you very much, Your Honor. Your Honor,
Have a
that
good day.
concludes my business before the court may be excused.
Yes, sir. Have a good day.
Thank you, sir. You as well.
Okay, let's get started with the reading of the script. With one count of violation of Georgia Controlled Substance Act, bond is going to be set at $2,000. One count of an open container violation, bond is going to be set at $500. And one count of misdemeanor possession of marijuana, bond is going to be set at $1,500. Do you believe you can post this $4,000 bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Miss Bond?
Yes, sir. Candace Bond.
Ma'am, you're charged with one count of obstructing an officer. Bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss, for the record, Heather Michelle Congo, I received a notice that she has a COVID diagnosis and she's in protocol. I have dismissed the obstructing of an officer charge, and I've set a bond of $1,500 on the given a false name, address, or date of birth charge. I'm going to send those documents over at the end of the day, so she'll be allowed to post a bond. Are you Miss, is it Houston or Houston?
Houston.
Miss Houston, ma'am, you're charged with possession of a firearm by a convicted felon in violation of Georgia Controlled Substance Act. I have an indication that you were on, that you were convicted of aggravated assault on November 4th of this year. So that would prohibit you from getting a bond at this proceeding.
No, I don't have no probation.
Were you convicted?
No.
Okay. All right, ma'am. Well, as of now, I'm not gonna set a bond. I'm gonna, ma'am, please let me finish.
Okay, yes, sir.
As of now, I'm not gonna set a bond. I'm going to look and make certain that you are not on probation or parole. If I determine that you are not on probation or parole, I will set a bond of $5,000 on the possession of firearm by a convicted felon and of $3,000 on the violation of Georgia Controlled Substance Act. Are we clear on that?
Yes, sir. When I will find out.
I just told you, ma'am. Ma'am, I can reset your case to tomorrow, or you can allow me to look at this and make a determination. And if what you're saying to me is true, I'm going to set a total bond of $8,000.
Okay.
Okay? The
Yes, sir.
way that you will know that, I'm telling you this information now so that if you're going to use a bonding company, you can start the process of contacting the bonding company, telling them your charges, telling them the bond amount the judge said he was going to set if you are not on probation or parole. They have a computer system where they will be able to know if it's been set. And they will tell you it's been set. Or they will tell you, no, it has not been set. The only other thing I can do is reset your case till tomorrow. You
Okay.
tell me which one you want me to do.
Set my bond.
Okay. So it'll be $5,000 on the possession of firearm by a convicted felon, $3,000 on the violation of Georgia Controlled Substance Act. You're going to have a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. And again, I just have to double check this because your information came over late and I did not have access to your GCIC, which is your criminal information. So I'm going to look at it. Now, it's pretty specific saying you were convicted out of Atlanta on November 4th of 2021 for aggravated assault. So once I get your criminal history, if it says that, you're not going to get a bond. Okay?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, do you have any other questions about what's going to happen next?
No, sir.
Okay, you're free to go back, ma'am. Miss Ramsay?
Yes. Good morning.
Good morning, ma'am. You're charged with one count of simple assault. I've set the bond at $2,000. Do you believe you can post that bond?
Can't pay it till Wednesday when I get paid.
Okay.
I get paid on Wednesday.
Okay. There's going to be a stay away provision on this bond to stay away from a Charisma Roberts. Do you understand that?
Yes.
What do you not understand?
No, I said I do understand. Yes.
Oh, okay. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. And looks like you refused the appointment of counsel. So you're going to hire your own lawyer?
Yes.
Okay. All right, ma'am. You're free to go back.
Okay.
Miss Yates? Ma'am, you're charged with one count of aggravated assault. Bond is going to be set at $10,000 for that offense. One count of family violence battery. Bond is going to be set at $5,000. One count of leaving the scene of an accident. Bond is going to be set at $1,500. One count of criminal damage to property in the second degree, and that's a felony. Bond is going to be set at $5,000. And one count of possession of a weapon during the commission of a crime. Bond is going to be set at $3,000. So you're going to have a total bond set at $24,500. Do you believe you can post that bond?
Not today.
Okay. There's going to be a stay away provision on the bond to stay away from a Kenyatta Glover. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, yes,
Okay,
sir.
you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Your Honor, that's it for female side.
Thank you for your assistance. Have a good day.
Yes, Your Honor. I'll get word to Ms. Congo as well.
Okay, thank you.
Yes, Your Honor.
All right, let's switch over to the male side.
Henderson.
Mr. Henderson, sir, you're charged with 1 count of possession of firearm by a convicted felon. I'm going to set a bond at $5,000. You believe you can post that? Oh, well, I'm sorry. It's going to be $5,000 for possession of firearm by a convicted felon and $500 for the improper lane change. Do you believe you can post this bond of $5,500?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I see you plan on hiring your own lawyer?
Yes, sir.
Okay. Do you have any questions for me?
No, sir.
Okay, Mr. Henderson, you're free to go back, sir.
All right.
There's a Holt.
Okay. Mr. Holt. Mr. Holt, sir, you're charged with 1 count of criminal damage to property in the 2nd degree. That's a felony offense. Bond is going to be set at $5,000. And 1 count of simple battery, that's misdemeanor. Bond is going to be set at $3,000 for a total bond of $8,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a Demeter Hall. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Holt. Mr. Jelks? Mr. Jelks, sir, you're charged with 1 count of DUI alcohol. Bond is going to be set at $5,000. 1 count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And open container violation bond is set at $500. All of these are misdemeanors. It's going to be a total bond of $7,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I don't.
Okay. All right. You're free to go back, sir. Maria, I just saw your text.
Yeah, I was actually, I see that, February the 7th is on a Monday, which is when we do felonies. And
Right.
then that Tuesday is for the misdemeanor, which is February the 8th.
Right. Which one do you think I got wrong?
I think, hold on just a second. It was a misdemeanor, that you did, and it was placed on the, 7th.
Okay. Find that person and just put it in the text.
Okay.
All right. Thank you.
All right.
Okay.
Langford.
I'm sorry. Say that again.
John Langford.
Oh, Langford. Oh,
Yes, sir.
what happened to Mr. Johnson?
Oh, I'm sorry. Ms. Johnson. I'm sorry about that, y'all. He's coming up.
No problem. Mr. Johnson, sir, you're charged with 3 counts of aggravated assault. Bond is going to be set at $30,000. And 1 count of assault on an unborn child. Bond is going to be set at $5,000. So that's going to be a total bond of $35,000. Do you believe you can post that bond?
I thought it was, my paper says 1 count of aggravated assault and another count. It was supposed to be 2 on the paper I received.
It's 3. Audrey Stovall, Dana Collins, and Devon Blango are the victims. Okay. So the bond's going to be set at $35,000 total. There's going to be a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir.
Okay, you're free to go back. Mr. Langford.
Yes, sir.
Sir, you're charged with 1 count of improper passing. Bond is going to be set at $5,000. 1 count of driving under influence of alcohol. Bond is going to be set at $5,000. An open container violation. Bond is going to be set at $500. And possession of marijuana edibles, which is a felony offense. Bond is going to be set at $3,000. So that's going to be a total bond of $9,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
At this time, thank you.
Okay, you're free to go back.
Mrs. Levy.
Sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond to stay away from a Linda Levy. Do you understand that? Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Mr. Price.
Mr. Price, sir, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000 for that offense. 1 count of criminal trespass. Bond is going to be set at $3,000. And 1 count of cruelty to children in the 3rd degree. Bond is also going to be set at $3,000. These are all misdemeanor offenses. The total bond is going to be set at $11,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Terry Pearson. Do you understand that? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, no.
Okay. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back.
Todd. I don't want to pay attention.
Mr. Todd, good morning, sir. You're charged 1 count of obstructing an officer and 1 count of public drunkenness. Bond is going to be set at $2,000 on obstructing of an officer and $1,000 for the public drunkenness. That's a total bond of $3,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I apologize for that. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. Just wondering, do you think I could do a signature bond? No?
No, sir.
Okay.
Okay, you're free to go back.
Thank you.
Is it Mr. Namachi?
Yes, sir.
Good morning, Your Honor.
Good morning. Sir, you are here on a slightly different situation. The same rights and privileges as I discussed earlier applies to you. However, you're here on what's called a fugitive from justice warrant. And what that simply means is that there is a warrant for your arrest out of the state of California. The Orange County Sheriff's Department has a felony grand theft warrant, and they've indicated that they will extradite you. And what that means is that Clayton County has no interest in this charge. We're simply holding you on behalf of Orange County. If you believe that you're not the person named in the warrant, and if you believe that, or if you believe that these charges are not valid, you can challenge this warrant. And what that means is that sometime between now and the next 90 days, there will be a hearing held here to determine if you are the person named in the warrant and or if the warrant is in fact for a valid charge. We have no interest in your guilt or innocence. It's not going to be a trial to determine whether you're guilty or innocent. It's just a matter to determine whether the right person is named or listed. If you believe that that is your true and correct legal name, and you believe that this warrant does exist, you can waive the right to that hearing. And if you waive the right to that hearing sometime within the next 30 days, Orange County Sheriff's Department, they will come and get you and take you back to California. If they determine, well, at some point within that 30-day period, if they determine they're not going to come and get you, they'll notify the fugitive squad here, and they will then release you. However, doesn't make the warrant go away. So you're going to have to deal with this at some point. Do you have a lawyer representing you out in California?
Yes, I am. I have a lawyer, but they're not. I haven't been opportunity to communicate with him really from here because all this happened so quickly yesterday at the airport. I was on travel. I was traveling to Nigeria, and there was stops at the gates when I was trying to check in.
At the airport, so you got arrested at the airport?
Yes.
Okay, so
because I was told by the officer who arrested me that there's a bond of a $100,000 bond to be charged. Okay, but if I can communicate with California, they will make a decision. But I don't know because I haven't seen all the paperwork myself.
So you should rely upon your counsel out in California. I had a similar situation that occurred, I believe, on the 23rd, where a person was traveling and they went to the airport and the warrant showed up and the person was arrested. And it was out of California. There was a bond set on the warrant. And so, hold on. The way that this works is like we can only talk at one time. And I promise when you're talking, I'll keep my mouth shut and listen to everything you have to say. Okay. So the person hired lawyers out in California. The person paid the bond out in California. They sent the information back here and that person was released.
Okay.
we cannot do anything as it relates to that bond out there. Okay. Even if I were to set you a bond here today, you still have the charge pending out there, and you would have to satisfy that bond. So if you waive your right to a extradition hearing, that starts the clock running today. It's your right whether you want to waive it or not. If you decide that you want to have the hearing sometime within the next 90 days, as I indicated before, you'll have the hearing. And if the judge determines that you are the person named and the charge is valid, that 30 to 60 day period that I referenced earlier begins to run after that hearing. So the effect of waiving a hearing is you speed up the process. However, you're going to have to deal with this out in California. So you need to hire lawyers out there. Have I sufficiently explained this to you? Do you have any questions?
Yes, you have. I have some questions.
Okay.
So if I get my lawyer in California to pay the bond in California, they could send the paperwork here and then I can be released from here, right?
Yes.
Okay. And then if I want a hearing, there's no bond. I just have to stay here until the hearing. Is that how it works?
Yes.
Okay.
Yes.
Okay. I have the paper here to sign the waiver of extradition, which speeds up the process.
Yes.
But while this is happening, can my lawyer still get the bonds taken care of and I still be released?
You said, can your wife do what?
If I sign this waiver of extradition, right? Can my lawyer in California, still take care of the bond over there and then
yes,
so I can be released faster here? Because I have a job that a lot of people depend on me. You know? I really want to attend to the case in California, honestly, because I believe I'm not the person. I've never been arrested before for anything.
Okay.
Okay, so this is definitely confused. Well, I wouldn't really say, but I know it's definitely not me because I never did anything wrong. I can recall, but it is a charge I have to address.
Yes, sir.
Yeah. Also, I just want to plead with you if they can make the accommodation here a little bit better for us, because where I'm staying is like we're laying on the floor here. It's really inhumane, and I don't know if I can stay somewhere a little bit more comfortable or private so that I can wait for this process. Because it seems like it's going to take a minute to resolve.
I do not have control over the jail.
Okay. So I should go ahead and sign this paper and then contact my lawyer. This warrant number here is the reference to the warrant, right? On the case. The warrant number 2021 W21468. That's written on the warrant that I have here. This paper.
And it's kind of hard for me to understand you with the there's like a little bit of an echo.
That's why I have my mask on. So I'm saying the reference number to the warrant is the correct reference, like this number. Is it also going to be the same number in California?
No, the warrant number, you have something to write with?
Yes.
The warrant number in California is W805361962.
I have WA0536.
The letter W, but the number 8.
Oh, 8. Okay.
05361962.
Okay. All right. Thank you so much.
Okay.
Also, how can I make a phone call to my lawyer? Because if I had called him, he would have been. Is there any way I can be given permission to make a call to my lawyer?
After you leave this proceeding, at some point in time, you will be able to use the phone today. Again, sheriff's office doesn't work for me. So they have to follow their internal policies. But my understanding is that if you have not used the phone yet, you will have the opportunity to use it once you leave this proceeding.
Thank you so much, Your Honor.
You're welcome. And once you sign that, they'll send it over to me and I'll sign it. And the process will begin to run today. But you should let your lawyers know, at least from my understanding of what happened last week, the state of California, because of the COVID related issues, that they're willing to work with people. And so if you go through that route, you'll be fine.
All right, Your Honor. I really appreciate you. Thank you so much, Your Honor.
Okay.
Your
All
Honor,
right. That completes the calendar.
All right, I just signed this and get it to you. Yes, sir. Yes, sir.
All 7 copies, all 7 copies.
Okay. And Marie, Miss Body, her violation of Georgia Controlled Substance Act is a felony offense. It's not a misdemeanor.
Thank you, sir.
You're welcome. All right. Thank you. Have a good day.